As Don Pasquale in Gaetano Donizetti's well-renowned and beautiful opera would have remarked, dell'età vecchia scordo I malani, mi sento giovine come a 20 anni, meaning that I forget the pain and the problems of old age and feel myself like a young man at the age of 20. In the very same way, the European Court of Justice, which has just concluded 7 decades of work, has managed to rejuvenate, despite its respectable age already, has managed to rejuvenate the Acquis Communautaire of the European Union in different, very multiple aspects, especially also regarding the matter of human rights. With these introductory notes, I'd like to thank warmly the head of the Elpis Network, our dear Professor Vasco Pereira da Silva, for giving me once more the opportunity to contribute to our traditional already Elpis V-Law Review for its newest issue. As you know, of course, already, typical actions in front of the European Court of Justice include elements of any sorts of violation of the treaties, annulment actions, actions for failure, especially regarding institutions of the European Union. But the most important, I'd rather say, of the types of actions which are to be encountered in front of the European Court of Justice, and the most important in regard for managing to rejuvenate, as I said, in certain ways, the Acquis Communautaire, would be the reference for a preliminary ruling, as it is based on the contemporary Article 267 of the Treaty on the Functioning of the European Union. In order to start with a slight historical flashback, due to the mainly economical goals which the treaties set for the further development of the communities back in the 1950s, the treaties themselves lacked for many decades any sort of a fundamental or a human rights catalogue. And in the following decades, up to the beginning of the 21st century, the European Court of Justice should play an important role in order to produce, one could say, community, nowadays union, fundamental human rights. And in order to do so, it used the European Convention on Human Rights and the member states' constitutional traditions as important sources to its case law. This practice led to certain irritations between the European Court of Justice and the constitutional courts of some member states, of course. Most prominently there, the German Federal Constitutional Court, the Bundesverfassungsgericht, issued some historical decisions which ultimately, of course, helped the communities, the union nowadays, in order to achieve a fundamental rights catalogue on its own. Of course, you will remember the Solange decisions and following ones like Bananenmarkt and more contemporary Honeywell. There is quite a plethora of decisions depicting the change in the view between the European Court of Justice and national constitutional courts here through the most prominent of the national constitutional courts of the European Union, the Bundesverfassungsgericht. At the end of the day, this bras de fer, in a polite way of course, between the European Court of Justice and national constitutional courts led to positive developments. And I'm meaning by that at the beginning of the 2000s, for the first time, the European Union achieved to have now its own fundamental human rights catalogue incorporated in the primary law. Up to then, of course, up to the 2000s, the European Court of Justice had recognized as community, or later on union, fundamental rights, for example, the principle of equality through the Klöcknerwerke case of 1962, the right to informational self-determination through the Stauder case in 1969, the principle of equality as well as the freedom of religion in the Price case of 1976, to just name a few. And as I had said, of course, before, it based its case law, interestingly enough, on the European Convention on Human Rights as well as the constitutional traditions of the member states. Again, the treaties lacking an official human rights catalogue. There was an important progress after the 2000s, as I've indicated before, and a huge Lisbon impact in regard to the human rights protection through the European Union. The Charter of Fundamental Rights of the European Union was written by a convent under the leadership of Roman Herzog, the former federal president of the Federal Republic of Germany and a former constitutional judge, of course, of the Federal Republic of Germany. This charter was solemnly signed in Nice in 2000, but it was not binding at the time. However, after the entry into force of the Lisbon Treaty, the charter became legally binding through Article 6, Para 1 of the TEU. And the main sources to it were also emphasized expressis verbis through Article 6, Para 3 TEU. A further development ex lege would be that the European Union shall accede to the European Convention of Human Rights in accordance with Article 6, Para 2 of the Treaty on the European Union, that of course being a delicate matter which would deserve a separate video. But having now the Charter of Fundamental Rights being legally binding is an achievement the fathers of the European communities in the 1950s had actually dreamt about, and at the beginning of the 2000s it came true. In order to give you a slight overview of the Charter of Fundamental Rights of the European Union, it starts with matters of human dignity, depicting, of course, the influence of the leadership of the convent which created the Charter. You know, of course, that the German Grundgesetz, the federal constitution, starts with the very same matter of Menschenwürde, and therefore also under the influence, obviously, of Roman Herzog, the Charter of Fundamental Rights starts with the very same matter of human dignity. In that first chapter, which regards dignity, other articles regarding the right to life, for example, and the right to the integrity of the person are included, which also show that the Charter of Fundamental Rights starts from its very beginning, on the most prominent places of the first articles, with elementary matters of our contemporary society. In the following chapter, an important amount of freedoms are enlisted, among others the protection of personal data, the right to liberty, the respect for private and family life, and many other elements. And further chapters regarding matters of equality, solidarity, citizens' rights, and matters of justice follow. As I said, this fine Charter of Fundamental Rights of the European Union is to be considered as being, of course, influenced heavily by the case law of the European Court of Justice, which I talked about before. and through which the European Court of Justice rejuvenated the Acquis Communautaire periodically. In order to conclude, one also should emphasize that since 2007, the so-called European Union Agency for Fundamental Rights has been established in Vienna, the capital city of Austria, which is of course mainly an advisory board to the European Union institutions and the member states, but also issues annual reports, and its legal basis is Regulation 168 of 2007, which of course rounds up matters of fundamental human rights protection within the context of the European Union itself. Therefore, it's obvious that through the case law of the European Court of Justice in the depicted area, it was pretty much capable and able of rejuvenating the Acquis Communautaire, and as it happened in other areas also, positivists of European Union law would here underline that the European Court of Justice was once more a spiritus rector for very important developments regarding the communities and nowadays European Union. Thank you very much.